Hi guys, welcome to LawPutra YouTube channel. I am Bhavna here. Today we are gonna discussing about the topic principles of jus cogens in international law. The term jus cogens might confuse you, but it's actually a simple and easy topic. The term jus cogens is either pronounced as jus cogens or ju cogens or us cogens. It is a Latin term which means compelling law. So, the term jus cogens, the term jus cogens is based on preemptory norms. Preemptory norms or established norms which is applicable to all states. It is acceptable by the majority of the states in the world is called as preemptory norms. The term norms is we all know. Let's just know the meaning of preemptory. Preemptory means which must be obeyed without refusal or excuse. The principle jus cogens is a kind of basic certain non-derogable principle. It is a non-derogable principle. That means there shall be no offenses against humanity. Like there should be no offenses against humanity. Example: genocide, maritime piracy, human torture, and also aggressive wars. There is no reason for committing a crime where we cannot go against, and we cannot give any excuses for that. Okay. Jus cogens provisions is set in Vienna Convocation on the Law of Treaties in the year 1969, VCLT. Okay, Vienna Convocation on Law of Treaties 1969 in the provisions articles 53 and 64. Okay, 53 and 64 in VCLT discusses about jus cogens provisions. Okay, let's move to the article 53. Article 53 says about treaties conflicting with the preemptory norm of general international law. Treaties conflicting with the preemptory norm of general international law. Let's just see this. Article 53. A treaty is said to be void. Okay, a treaty is said to be void if at the time of its conclusion, if it conflicts with the preemptory norm of general international law. For the purpose of present convention, a preemptory norm of general international law is a norm recognized by the international community of states as a whole as a norm from which no derogation is permitted. No derogation is permitted and which can be modified only as a subsequent norm of general international law having the same character. Okay, a treaty is said to be void if at the time of conclusion, if it conflicts with the preemptory norm of general international law. Preemptory norm discussed as earlier, no offenses against humanity like genocide, aggressive war, etc. If these are in treaty, that treaty is said to be void. Okay, I hope you are clear with Article 53. Now let's move to the Article 64. Article 64 says about emergence of new preemptory norm of general international law. Let's go details. If a new preemptory norm of general international law emerges, any existing treaty which is in conflict with the norm becomes void and terminates. Okay, let's just hope there is a new preemptory norm emerges in the state, and there is a treaty based on that preemptory norm. Then it is under Article 64, that treaty will be treated as void and it is terminated as per Article 64 of VCLT. Okay, this says about if a new preemptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. Okay, I hope you are clear with Article 53 and 64, under which comes under jus cogens. Okay, the topic jus cogens is a controversial topic too. Some scholars criticized it. Let's just see the criticisms on the topic jus cogens. Jus cogens, the scholars said that in international level there is no such thing as jus cogens or established norm. They decided and said that there is no topic such as jus cogens or established norm. There is no proper definition of what is not included in jus cogens. As discussed, Jus cogens as preemptory norms includes there should be no offences against humanity like genocide, aggressive war, or maritime piracy, etc. These are, if these are included, then it will be comes under jus cogens, and the treaty will becomes void. And the scholar said that there is no such thing included which are not included in the definition of jus cogens. Okay, it is not written anywhere, and it is just decided by one's understandings. Okay, by seeing the treaty, if anything such as preemptory norms includes, that treaty becomes void. It's just based on our understandings, and there is no proper list to define what comes under this. As we discussed earlier, there is no proper list to define what jus cogens is. I hope you are all clear with this topic, jus cogens. Let's simply replay it. The principle of jus cogens is a Latin term which means compelling law. It is based on preemptory norm. Preemptory norms is which is obeyed without any refusal or excuse. It is the provisions of jus cogens inside in Vienna Convocation on the Law of Treaties 1969 under Article 53 and 64. Okay. I hope you all understand the topic principles of jus cogens. If you have any doubts, please leave it in the comment section. I hope you like the video. Thanks for watching the video. Please do like, share, comment and subscribe to the LawPutra YouTube channel. Thank you.